Are you ready?
Are you ready to call?
Are you ready?
262-394-6555. 262-394-6555. Hit it.
I saw you were with them last night. I saw you were with them last night. Don't burn the bridge, burn the paper.
Yeah, that's Don't Burn the Bridge, Burn the Paper by Engaging Time, coming to a venue near you. Engaging Time, by the way, is yours truly. Engaging Time, time with a Y. And we're going to be coming out soon, folks, but right now both of my guitars are having a bit of surgery, to say the least. So it may be another month or so before Engaging Time gets out there, but I can promise you we got some new material, got a bunch of covers, and I'm looking forward to getting out there. I'm hoping that my friend Dale or my friend Rupert will join me as protection, because if I screw up, I just need to turn to them and say, take over. So, welcome back, everybody. This is 101.5 FM, WLCB, Slade's Corner, Wisconsin. My name is Bill Miksch. I am president of WDMA Financial Group in Grayslake, Illinois. And this is your Insurance Corner. And for the next 30 minutes, we are going to cover topics that you are going to need to know. And tonight's topic is what happens if I have a will, and what happens if I don't have a will when I pass away. Because there is a big, big, big difference, folks, as to having a will and not having a will. But let me dispense one critical aspect of this. Whether you have a will or you do have a will. So if you do have one, great, makes things orderly. If you don't have a will, the state in which you live in has a will for you. And you're probably not going to like what happens if you die without a will. So we're going to get into that in a second. And if you have multiple properties in multiple states and maybe titled in different ways because that's the way you wanted to do it for whatever your crazy reasons were, every state that you own property in is going to get probated if you have a will or don't have a will. So we ended with, what do you have? What are your liabilities? How do you want this to be dispersed? Who gets what? What state do you live in? Do you live in a community property state like Wisconsin? Or do you live in a regular state like Illinois where titling makes a difference? And titles to property are a big deal. So what happens? First thing I want to tell you is a will is going to guarantee probate. It does not avoid it. I've heard this before. A will does not avoid probate. It guarantees it. It just makes things difficult if you don't have a will. The state in which you live in has one for you. Now let me just share an oh by the way clause. So let's say you have a house that's joint tenancy of rights of survivorship. That means you and your spouse own the house jointly. You pass away, the house goes to your spouse. Period. Full statement. But what about the cars? Let's say the cars weren't in your name. Or worse, for whatever the reason, you never put your spouse on title. And there's no will. You pass away, she's homeless. Maybe not in the short term, but she's going to have to go to court and figure out how to keep the house in her name or get it into her name. And the one thing I can tell you, folks, is probate is the gift that will keep on giving the attorneys. The attorney will always get paid first out of the estate before any disbursements take place with regard to the assets of the estate. Now, there are certain exceptions to this. Life insurance proceeds, if the beneficiaries are up to speed, those avoid probate. You just need a death certificate, fill out a couple forms. You might wait anywhere from 5 days to a month, depending on the quality of the insurance company and who's handling the paperwork. But a life insurance policy will generally avoid probate because the beneficiary gets first dibs. Now, if there is no beneficiary in line, folks, that money will now go to probate and become an asset of the estate. And now, theoretically, creditors have access to it. And let me talk about the creditors here for a second. So whether you die with a will or without a will, it's a very public forum. Nothing can happen to the estate for a minimum 3 to 6 months. Nothing can happen. The process has to be open to the public. Everybody from one end of the world to the other can know that Johnny Lunchbucket passed away. And if Johnny Lunchbucket had some moving parts in his life, any creditor that wanted to poke his finger into the estate could. By law, they could, and they have a right to do it. If you die with a will, things are more orderly, but the creditor can still poke a hole in the will in the estate. They may have first dibs at a crack at certain assets, particularly the house. The house has to be retitled. It may be given to one of your kids, but if the estate owes money to credit cards or a lender of some kind, the lender gets paid first. The creditors get paid first before you get anything. So it may end up that you have to sell the house to pay off the debt, and then you get whatever is left, if there is anything left. So life insurance proceeds are going to, if it's done correctly and you've got beneficiaries in line, you're going to avoid probate. Transfers on death, which is same as beneficiaries, except that's in the banking and investment community, those will generally avoid probate. But properties that are titled have to be transferred. Properties that aren't titled but are in the name of the decedent may have to go through the probate process, especially if they are collectibles or things that may have some value. The one thing I do want to bring up, though, is life insurance owned by a corporation, and the person owns the corporation. Depending, again, how he's set up, if they have a will, that corporation may be subject to creditors, and typically, if a life insurance policy is owned by the corporation, it's very likely that the corporation is also the beneficiary. It gets into executive bonus plans and deferred compensation plans, and it becomes an asset of the company. Well, guess what? If it's an asset of the company and it's cash, it's now accessible by the creditors. Again, it's a public forum. The tax man is going to get their piece of the action. Your 401ks are all taxable, and that's not going to be any different whether you do a will or not have a will or a trust. The IRAs, if they're traditional IRAs or 401ks, they're definitely going to be taxable. If you have investment holdings that are outside of an IRA, these are called non-qualified investments, for example. They're just stocks, bonds, mutual funds, etc., that you hold at a brokerage firm. Those are going to be part of your estate, and if the beneficiaries are up to snuff, the beneficiaries get them. If they're not, they may be a part of the estate asset and may be subject to collection by the creditors. So what happens if you die without a will? This is not good, folks. First of all, you're going to have to go to probate. State in which you die, let's just say it's state of Wisconsin. State of Wisconsin has a whole list of how the estate is going to be broken down. If there are children in play at all, the surviving spouse will get 50% of the estate, and the kids will split the other 50%. If there are no kids in play, then the spouse will generally get a full share of the decedent's estate. But in a lot of cases, there's children involved. If there's no surviving spouse and no surviving kids, then the state's going to look for cousins, aunts and uncles. Your surviving parents could still be receiving assets even if they're older. If the spouse and kids aren't there, it's probably looking for your parents first and then your siblings. And if you don't have good relationships with your siblings and part of your estate's going to go to them, you may be rolling in your grave, folks. The will, if you die without a will, the court is going to supervise it. It's going to be very expensive. And because there's no will, it doesn't stop anybody from, throwing their fist down on the table going, hey, he promised me this, and they can challenge it and draw things out. Probate ensures an orderly process, but without a will, it's not orderly. It's going to be chaotic. And if you got multiple properties in multiple states, every state is going to have their own probate, which means you have to hire an attorney in each state that you have the property in. You don't have a choice. Don't have a choice. Can't just let it go. The state is responsible, and if there are taxes involved, the estate and who's ever responsible for managing the estate is going to be responsible for paying those taxes out of the proceeds from the estate. So, not having a will, the court will then appoint a trustee to manage the estate. It could be the attorney if the family members are fighting amongst each other, or the court could just say, we're going to pick one and have a successor. And the court may decide who is the trustee. And again, if the family's fighting, they're likely going to pick a third party who's got no skin in the game, except that they're an attorney or that they're going to get a fee just because they're doing something on behalf of a decedent's estate. So it's really critical if you die with a will, without a will, it gets really messy, really fast. And there's no protection about making sure certain people get certain things. It won't work to say, well, my dad promised me I was going to get that pot of gold over there. Is it in writing? Where is it? Where is it in writing? If it's in writing, we'll look at it. If it's not in writing, words don't mean anything. It's hearsay. And since the person has passed away, there's no way to confirm or deny that promise was ever made. So then what happens if you do pass away with a will? What happens then? Well, that's better. So you as a decedent, as the person who's designing the will, have control now at least of how the assets are going to be dispersed. And you can do whatever you want within the law that the state in which you live in allows you to, but you can pretty much do whatever you want. And you can disavow certain people in the family or in your estate. I can tell you my dad put in something in his trust that basically said any family member that causes a problem will be out. You can do that. While you're alive, you can change things on the fly. No questions asked. As long as you initiate the process the correct way and get the appropriate signatures and cross signatures and redate it. And then it doesn't have to be filed with a court. It just has to be somewhere where a lawyer or a judge can look at it and go, yep, that's legit. What does a will not do? Will does not avoid probate. It just makes it orderly. You're still going to have challenges to the estate, either by family members that think they're entitled to something. As an example, folks, for those of you who may not know, George Halas, Papa Bear, who owned the Chicago Bears from the beginning until he passed away, ended up in probate for 20 years because he only had a will, and the Hallis family is huge. Virginia McCaskey, who just passed away, had 11 kids by herself. They had a huge family, and everybody and their uncle had their hands out, that they thought they were entitled to the piece of the Chicago Bears. So Papa Hallis was, after he passed away, his estate was in probate court for 20 years before it was finally settled. Creditors still have access because it is a public process. Spouses may still only get 50%. And again, this is now being dictated by the person who is now 6 feet under. Ex-spouses may or may not be in play depending on the circumstances. Kids certainly will be in play, but state rules apply. Attorneys will always be paid first. Attorneys will always be paid first. And when I was putting this thing together as part of my research, if you didn't have a will, folks, and you had a sizable estate, and sizable is maybe $500,000, $250 million or more, and you got maybe one house, maybe a cottage somewhere in northern Wisconsin or in Florida somewhere, or a condo somewhere. Maybe you have a boat stored somewhere else in a different state. The probate costs can run anywhere from 1% to 5% of the estate. That's a lot of money. And if the estate's not liquid enough to handle it, court's like, too bad, sell it off until you can pay for the estate. The other thing to know, too, is the estate will have at least one more income tax filing before the estate is closed. And sometimes, and again, we're not going to get into trust, but if you have a trust, that trust could have its own income tax form filing every year, so long as that trust is still in existence. Talked about the average attorney's fees can be 1% to 5% of the estate, depending on the circumstances and the complexity and whether or not there's going to be problems. A simple estate is still going to cost couple $1,000 maybe. I never did ask my sister, so if you're listening, if you want to text me and let me know what the attorney charged for Dad, that would be interesting. My dad did not have a big estate, but he had an estate. It was bigger than we all thought. That's for sure. At a minimum, folks, you want a valid will. And just like powers of attorney for kids, even if the kids don't have much of it all, they still have debt. And in some cases, the debt is co-signed by the parent. That debt does not go away, folks, because the child died. If you co-signed, that debt now becomes your debt. And the person who passed away, who is 19, 22, 32, 35, still single, no kids, no imminent danger of getting married, and then passes away, they have an estate. And if they die without a will, you're going to be subject to the same rules I just outlined. So your children should, at a bare minimum, have a will. And I'll tell you again, I think it's really critical if you want to put in something that says anybody that causes a problem, particularly family members, you're out. I would put that in there just to save yourself a lot of aggravation. So having powers of attorney are critical for property and for health care. They cease to exist when the decedent passes away. The will is critical because it allows for an orderly process to dissolve your estate and have your assets passed to the people that you want it passed to. The estate is still going to go through the examination from the court. It's still going to be public. It's still going to be open to the public. But not having a will becomes a much uglier thing because the courts now get to make a decision. as to who's going to run the estate, manage the estate, to manage the assets, and there's some legal liability there, folks. So, and if you don't know what you're walking into, it's kind of like the proverbial buyer beware. Oh, goody, I'm the executor of the estate. Oh, such a nice thing to do. I feel real honored to do it. And then you open up the books and you're like, oh my God, what the hell was I thinking? But a will is still important. It still allows you to push things through on an orderly basis. You as the author of the will have complete control over where things go and how things get dispersed. And you can change things so long as you have capacity. The moment you start to lose capacity, that's where durable powers of attorney come in. However, the power of attorney does not necessarily allow the power of attorney to manipulate or change or amend the will. It does not. In fact, it forbids it, because the person who designed the will can no longer act on their behalf, and the power of attorney does not extend to that extent. So that's the power of attorney. That's the will. Die with a will, at least it's orderly. Die without a will, good luck. Good luck, Henry. It's not a good thing. If my listeners are out there and you want to pose a question, it's area code 262-394-6555. I promise you, if I recognize your voice, I will not blow your cover. For those of you who are listening who have my cell phone, you can text me. Same thing, I will not blow your cover. In the next few weeks, we will be covering revocable trusts, irrevocable trusts, trusts that allow for income to be passed from one generation to another, charitable trusts, irrevocable life insurance trusts, something called a Q-tip, which is a qualified terminal income protection trust. I like to call those the trust to protect you from the silver-tongued devil, who may try to woo you out of your money. And don't think that won't happen. There are different kinds of trusts that, again, we're going to talk about. You've got Medicaid trusts. You've got special needs trusts. As I said, charitable trusts, life insurance trusts, a Q-tip trust, as I mentioned, and a litany of other things that we're going to cover over the next week or two. That gets complicated, folks, so we're not going to blow through everything in one show next week. We're going to cover the basics of a revocable trust. Whether you're a single person or married, doesn't matter. Typically, a trust, when you put it together, will have what's called a pour-over will, because inevitably there will be assets that you never moved into the trust. It happens all the time. But if the estate planning attorney knows what they're doing, they will have a pour of a will that basically says whatever was left out of the will gets whatever was left out of the trust gets poured into the trust upon death of the decedent. There may be some modest probate stuff that you have to go through, but if the trust was done correctly, the pain of the probate will be minimal. I cannot underscore enough the idea of making sure your properties are titled and your beneficiaries are up to speed. Really, really critical. So with that, I'm going to read you. I haven't done one of these in a while. Hold on a second. I just got a text from one of my wonderful listeners. And hold on a second. She says, the cost depends on how complicated your assets are. Yes. The Cost also varies on how much it will cost you to get a will, a trust, or powers of attorney, etc. You may also need to decide if you want a trustee to manage it over time after your death, correct? You will also need a employer identification number for the trust after death, which is what I explained before, is that the trust now becomes its own taxing identity, ergo the federal tax ID number. So thank you, my listener friend, for chiming in. I'm going to go back to this. I've got 1 minute to do this. My wife and I are celebrating our 34th wedding anniversary this weekend. So my honey, I love you. I've adored you from the moment I met you. Your smile has the infection of a million stars. And I hope to be able to say this for another 34 years. We'll be very old when that happens and maybe drooling on ourselves, but it will be definitely worth it. So with that, this is 101.5 FM WLCB, Slade's Corner, Wisconsin. This is your Insurance Corner. My name is Bill Miksch, president of WDMA Financial Group. Have a wonderful night, a wonderful weekend, and we'll see you guys hopefully next Tuesday with another excursion into your Insurance Corner. Have a great night, everybody. Take care.